Possible matter under the order serial number 9, MN number 327 of 80.
In this case, insurance company the obtained mallards, and earlier notice were issued upon the parties mallards. It seems the owner has not appeared mallards.
Right to recovery granted.
Mallard, for that mallard, this entire case is the mallards.
You are praying for right to recovery.
Mallards.
On what ground?
Mallards, there was no DL permit. We had issued 134C notice even, and the tribunal had put the liability upon us. I was relying on popular other judgment on that score. Mallards, the first owners lies upon the insured, that is the owner. This is a case of DL and permit. There was no DL and permit. Mallards.
The owner had not appeared before the court below.
Mallard, he had not, copy number 2, he had not appeared, Mallards.
How many days limitation?
Limitation is 49 days.
49 days. 49 days delay condoned. Will this case under the heading for admission along with the LCR?
Okay, please. I'm sorry, my lords. Today, 2 of my office juniors,
The other junior whom you have said you should have given him instruction.
my lord, I just told him 50 minutes ago, my lord, because of the matter of court.
There are other matters also.
My lords.
Yes, next.
Serial number 50, MN number 453 of 80.
My lord, in this case, we are directed by such a petition, my lord. We are sent to 5 investigator to the house of the owner, my lords. Unfortunately, on all the 3 occasions, the door was locked. The other person, they have consistently been saying that usko dekhe means.
Yes.
My lord, that's what I asked them to get a statement in writing of the neighbors. So I was praying for 2 weeks further time, my lords.
What is your ground in this appeal?
My lord, the DL, my lords.
It is fake.
My lords. My lord, if I may perfect, my lords. The owner, he failed to produce the DL, my lord. And my lord, and we have issued letters to the owner, my lord.
No. Just
If my lord may kindly sit down number 9.
driving license was there. It is in the chart sheet. The driving license number must have been there.
My lord, if Dr. may kindly see down number 9, para 5, my lord.
No one is appearing.
My lords.
Notice has been issued.
My lords.
Because the buyer of last injured 6 weeks time is granted to the appellant to comply the earlier order.
My lords.
Very which this appeal will stand dismissed against the owner of the vehicle.
My lords.
Serial number 21, MN number 534 of 80, Mr. Sandeep Verma.
No one appears on the second call. This case is adjourned for 6 weeks.
Serial number 50, under the heading final hearing, first appeal 87 of 20, Mr. Mansoor.
Yes.
Say,
Take your seat. Yes. So the original notice under section 11 has not been executed.
not
Where is the award?
Lordship is seeking my submission of Lordship.
Award. Where is the award?
Award Lordship.
Exhibits.
Award number 9. Award also not executed.
Award also not executed. And what have you prayed for enhancement?
Yes, Your Lordship, it was free for enhancement. We get-
What? You say that the award is bad, the award is also not executed. In absence of the award, could the court proceed? Tell me.
Because Your Lordship, I indicated that since it was admitted fact that the land has been acquired, so it was only on a matter of quantum. So we started with, state did not exhibit any document.
No, it was-
What we exhibited is,
State had not objected anything, it was the onus was upon
yes,
the
Your Lordship. So we started, Your Lordship, we brought on record. And we exhibited the documents to show that those were our plots.
address on the issue whether in absence of the award, you could have challenged the award before the tribunal, the authority, land acquisition authority. Because what is the amount of compensation? It is there in the award itself. You are challenging the award.
It is in exhibit 4, Your Lordship. Exhibit 4 shows the area also and the amount also.
But that is not the award. What have you challenged?
Challenge was it.
No?
Those wait for the demands matter. We place the
You show me any judgment wherein where the award has been challenged in the land acquisition case, maybe on the ground of quantum or anything, without the award the court can proceed. Where is the judgment? Appeal judgments.
yes 31.
Page
31.
There's a reference. Where is the reference order?
A reference order which is executed.
Show me that is the reference order also. What is the order of reference?
Reference order. Exhibit A also.
Annexure A.
Exhibit yes, sir. Exhibit
Yes, exhibit.
Exhibit A. Or in letter number 14 from exhibit B.
No,
No, check, no. That is
Where
not
is that?
also lordship.
Where is the reference? Where is the reference to the court?
Reference. Letter number 461 also. On 20/6/2019, which reference also not.
Letter number 461.
Letter 461 also. Letter number 461.
That is at page 1 to 3. Case number 9.
Yes, number 9.
Have you gone through the order dated 27/2020? है आपके पास? नहीं है? क्या बात है? See the order dated 27/2020. No, not this one. BJP. एविडेंस सर्टिफिकेट आप भी देखो। These are all photocopies?
All photocopies.
How can photocopies be exhibited? Tell me. What is the provision of law
Lots of kinds.
exhibiting photocopies?
65 evidence set.
But the judgment shows, Your Lordship, that the mutation order at extra certified copy, like the sale deed. And
What are the photocopies and what are the certified copies?
All the document right by the judgment got saved.
Are
All the
photocopies
document are
certified?
photocopy.
You read that order. What is that order saying?
An application has been filed on behalf of the petitioner for exhibiting documents. It is stated by the learned counsel for the petitioner that he has filed certain documents which needs to be exhibited for proper adjudication of the case. The learned GP for the opposite party stated that the documents already placed on record by the petitioner are admitted documents, and there is no dispute, and as such the same may be marked as exhibits. I have considered the submissions of the both councils and also it transpires that most of the document details of which are mentioned in the I have already placed on record, and there is no dispute raised at any time by the GP, since the documents are necessary for proper execution of the case. Accordingly, the application filed on behalf of the petitioner stands allowed, and documents relied upon in the application.
Just my next question would be, both have to answer. Merely by the GP admitting, lawyer of a party admitting that document, can that document secondary evidence be admitted in evidence? Merely if a lawyer says, this is a law,
My lord.
can there be any estoppel against law if the court wants to enter into this question now? Or can you bypass the provision of law just by agreements? Can you waive the condition of law of evidence? what are the documents which were photocopy and what were original or certificate. What is secondary evidence? 63. What is 63 says? The evidence. Secondary evidence means and includes certified copies given under the provision herein after contained. Certified copies also. Copies made from the original by mechanical process, those are photocopies, which themselves ensure accuracy of the copy and the copies compared to such. The copies made from compared with the original counterparts of a document, original accounts shows. These are secondary evidence. 65, you read 65. Secondary evidence may be given of the existence, condition or contents of a document in the following cases. When the original is shown or appears to be in possession or power of the person against whom the document is sought to be proved, or of any person out of reach of any person legally bound to produce it. And when after the notice mentioned in 66 such person does not produce it. When the existence condition of the contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. There has to be the person who has written. Yes, he should admit it. This is in my writing. Nothing has been done. This condition has not been followed. When the original has been destroyed, it is also not the case. When the original is of such a nature as it is not easily movable. When the original is a public document within the meaning of section 74. What are the documents, public documents in this? Then you have to refer 74. When the original is a document of which a certified copy is permitted of this act by or any other law in force to be given in evidence. When the original consists of numerous accounts or other documents which cannot conveniently be examined in court. Your case falls in C. It says in case of A, C and D, the secondary evidence or the contents of the document is admissible. In case of B, the written admission is admissible. In case of E and F, a certified copy of the document, but no other kind of secondary evidence is admissible. E and F. That means when the original is a public document, if you say that this is a public document, then only certified copy is admissible, no other document. Your photocopy will also not be admissible.
We should also put judgment past by
74. Following documents are public document. Documents forming the acts and records of acts of sovereign authority will not be your case. Of official bodies and tribunals. So the award, the assessment, it says only the certified copy will be made admissible and no other. So whether the court would have seen all these documents which could have marked as exhibits. And my next question is, if the court couldn't have marked this as exhibit, there is no document on record, how would this judgment be? Can you answer these questions before 12th or 13th? I am asking you before, that is why I am asking you, can you answer this question before 12th or 13th? 13th is the last date, is impossible. Are you in a position to answer this question? Before तो होगा, next कल मिलेगा, कल डेट मिलेगा, उसके बाद नहीं मिलेगा. This is not a case where it cannot be heard in a virtual mode. It's absolutely impossible. Virtual mode में this interaction will not be there. There is बहुत देखना पड़ेगा इसमें.
About, actually, what my information was immediately land was acquired. That is not.
Which land was acquired? Which land was acquired? Award is in respect of what? Which land? Where is the award?
What is not there?
That is the second hurdle which you have to cross. That is the second hurdle which you have to cross. The award is not on record. The notice is not on record. Find out whether in absence of the award, whether reference was made. Award was prepared and reference was. What is the reference? Where is the reference?
Letter number was.
Read the reference.
Would they not see it?
Because admittedly an award was prepared.
Yes,
Award was prepared.
But this is it.
Reference is how can these documents be exhibited? Who will exhibit these documents? This is 65. There should be some statement by originally I am producing. Who will exhibit the job? No one has done that. It's merely a petition. On a petition, it has
No any witness was exhibited.
that we'll see later on. But
the fact is
Well,
that no objection was made by either of this. Either HB also he admitted.
suppose you say I want 14 crore rupees. If the GP admits yes, he is entitled for 14 crore rupees, is it the duty of the court to just on his concession of the GP to pass an award for 14 crores? The court will not see the legality. The legal aspect it is for the court to see. God knows whether there is some.
Got
You got it? Merely accepting or they're not opposing, that doesn't mean that it becomes easier for the court. It's become more so difficult for the court.
in absence of award, that is what you understand. I have to
In
examine.
absence of award in this
No, I commit all this.
63,
The fact
63.
is that when the award was prepared,
65.
no, when the award was prepared, my lordship, meaning that the land was acquired, so only the quantum was missing. And the quantum is on the basis of the.
Let us read. Let us read this. भूमि अर्जित पुनर्वास एवं पुनर्निर्मित प्रतिकार एवं पारदर्शिता के अधिकारियों से संशोधन धारा 76 मामला के अनुसार है 76 है. It is a wrong reference. Read 76.
When the amount of compensation has been settled.
So amount of compensation is settled. This presupposes the amount of compensation is settled. Then the question, right, read that.
If any dispute arises as to the apportionment of the state or any part of it, or as to the persons to whom the same or any part of them thereof is payable, the collector may refer such dispute to the authority.
It's only question of apportionment. That how much X will get, how much Y will get, what person will go to X, what person will go to Y. Is this the case?
Actually, it should be under section 64.
So is this reference correct? If the reference is bad, then this reference be under section 76?
Cannot.
Then? Note down. You have to answer this. The reference made under 76.
6.
Whether this is actually a reference under section 76. If
Yeah, 76
if this is
is
not under
not.
76, then what?
64.
Then what will happen? What are the judgments? That even if it is written as 76, if it is the intent is of 64, it will make no difference. Then you have to argue, you have to make out this point. You have to come with these judgments. Then even if it is written 76, but the intent is 64, then mere writing 76 will not change the nature of reference. इलेक्शन है आपका, नहीं पता प्रेसिडेंट, आप इस सब में क्या मिक्स कर पाए?
नहीं, हमको लगा कि बहुत अच्छा केस है मेरा।
तो कहाँ गड़बड़ा गया?
तो लगता है केस ही नहीं, सब पूरा जीरो हो गया। State did not do anything there, and they are such a good case. They did not examine any witness, and they did not.
I don't know. I don't know.
And
I don't know. Now it is up to you who can say.
they are in possession of the land since 2019, not paid a single party to us.
This 76, it can be, you can overcome this.
I'm very sure that what the
You
later,
have
what
to-
will
you have to formulate this. You can- Let us see what is the reference. बॉडी में भी 76 लिखा है, ये तो doesn't. You see the next annexure, you don't have this copy also.
no.
Tell your client to get all these copies.
No.
You see this? पहला पढ़िए तो, पहला लाइन पढ़िए, पढ़िए जोर से।
Reference to the court under section 70.
ठीक है, sure.
The right of consent, the application and the settlement act 2000.
हाँ, उससे बात पढ़िए। Read thereafter.
Where a dispute exists between the parties interested or between.
Between the parties interested and
As to the appointment of compensation.
apportionment.
Apportionment में नहीं
This is-
लिखा, appointment.
पर apportionment होगा. In this, the parties interested in apportionment. That means
When no party
it
has
goes to a
I
party.
had a dispute with my
Yes,
husband and
your mother, husband, and
Yeah.
son.
settled by me in the law made under section 2 of the Act 1 of 1984, of which a copy is here annexed. I have referred such dispute.
That means, why this dispute is being referred? Because he is not in a position to decide that what would be the apportionment, who is entitled to get what share. That is why the award. So just see whether any award is annexed with it or not.
No, award नहीं होगा,
उसके बाद क्या है? Your application है?
मेरा application.
Your application is there. give me the. This you can overcome. You need judgments and the proposition of law. You have to. Because the document shows this is under section 76. It should not be. Where is your application? Before the collector?
The collectorate was some application date.
कहाँ है वो? What is that? Because 64 also. This is not an application before the collector.
No, that is not.
It says, provided that the collector shall, within a period of 30 days from the date of receipt of application, make a reference to the appropriate authority. Your application is not there. How do we know that it was referred within 30 days? Take down next point. क्या होगा? कब कीजिएगा? इसमें समय लगाना पड़ेगा.
मैं बोले के बाद
That's why I'm saying कि 12 तारीख में आपका mind is diverted towards 12.
नहीं
Mind is diverted towards 12.
नहीं पता चला.
Otherwise, if not you are sure for a runaway without any opposition.
नहीं
Then it is not that, that you are.
Let it come in the second, third week of the month of June or Russia.
फर्स्ट अपील है, बैठना पड़ेगा आपको इन लोग के साथ, इन लोग दौड़वाना पड़ेगा.
Otherwise,
Also, one might argue, Minister of Education has already visited the institution and given the notice to the DC Lord Seal.
नीचे लगा.
So kindly stay the institution.
तो जो स्टे हो जाने के बाद क्या होगा ना, स्टे नहीं था तो स्टेट काउंसिल आ जाते तो उसके बाद तो टाइम नहीं लेने लगे.
नहीं हम नहीं तो जब भी क्या रेडी रेडी. I will say 6995.
कौन प्रोविजन में फाइल किया इससे?
Order 41. Order 14 will go to 5%. This is a
This is a money degree. This is a money degree.
Just like what money.
This is a money degree.
Yes.
What are the conditions for saying a money degree? How, on what condition and how a money degree can be saved?
Lordship, yes, Lordship, this is pendency of this
On what condition money degree can be saved?
Condition Lordship, that is the award is judgment is passed. Without
What is the stage of the execution case? What is the next stage?
Lordship issued a notice and demanded for DC to given the assets of the DC office.
DC assets का list मंगाया ना अभी. Assets का list कौन से कब asset का आएगा?
Only no person.
No persistence in a civil. First step is a very vague one. I don't want to use vague one. There's this case on the request. Is this case on? Yes, madam.
14 June, Your Honor.
You will be ready by 14 June?
I'm on.
14 June. In the meantime, let the original lower court record be called for. उसमें पता चल जाएगा which are photocopies which were exhibited and which were original.
From the notice, from the executing of court lordship, that the उच्च न्यायालय स्टूडेंट्स दे हमने था this fight कर दिया
मामा है ना
स्टूडेंट
Criminal cases, serial number 23, MN number 545 of AD, Mr. Amit Kumar Das.
Doctor, in this case,
Yes.
case notices were issued upon respondent number 5 and 6. However, due to inadvertence, it appears that you did not file the requisite.
Petitioner to comply the applicants to comply the earlier order by
Project 2 weeks.
10 June.
Serial number 24, MN number 572 of AD, Mr. Mahesh Tiwari.
Lordship, I think before this court, Lordship to kindly pass over the matter.
Why?
As the London Council is engaged in the matter.
Why this case has been listed today? Why this case has been listed today? Tell me.
This is listed for
Why it has been listed today?
Lordship and would have been instruction regarding this.
You use the mic.
Lordship and would have instruction regarding this.
Who are you? You are JC to Mr. Mahesh
I will say.
Huh?
Yes.
What is your work? What is your duty? Only to carry the files. Has anyone taught you that in orders cases you have to go through the office now? Has your senior taught you? That you have to go through the office note, why it has been listed? It's a case for orders. It is also not a case of admission or hearing or ABC. It is only for orders. So you should know that why, you should at least have an interest to know that why it has been listed for orders. You should go through the office now. And then say whether it is necessary for your senior to assist this court or not, or you can do it yourself. How many years of practice you have put in?
Sir, Lordship, I will just
2021 number.
2021.
21.
So, listen to me. When a case is listed for orders, you take the file from here, the last page of the order sheet, there is an office note. The office note will, from the producer of the office note, you will know why the case has been listed for orders. Either there are some defects or some petition is to be moved, and not for hearing on merits. You should go through it and you should understand. And if you don't understand, if your senior is not there, there are several lawyers who will happily assist you. Now go through it. Be informed. The last page of the order sheet, you will find the office note. Go and read the office note. What are you reading? Last page of the order sheet. Mr. Counsel, you don't know what order sheet is also. Mr. Manish Kumar help me. COVID batch. All online. So there is nothing physical or practical here. So assist him. Naturally, the COVID batch will also not know what is an order sheet is, what is the color of the order sheet, original code order sheet. Read that, let me make him read it.
This memo appears by my indication of defect and all the defects are being removed.
So there is no defect. It is barred by 83 days. What is the IA number mentioned there?
Number 7135 2019.
Find out this IA. Find the IA from that. Where is that? This is for continuation of delay.
Continuation of delay.
This application is filed under section
Section 5
of the
Limitation Act.
Limitation Act. Take your brief. Now turn to that petition. Just tell me, what is your ground for praying for condemnation of delay? Don't worry. Relax and tell me.
Document number 1, Amendment 6, being the senior citizen, senior ladies, age of 65 years and 66 years respectively, have been suffering from suffering from maintenance as such. The present not defined the restricted period.
So in paragraph 4, you say that mainly the appellant number 1 and appellant number 6 being the senior ladies and senior citizen, aged about so and so, they were suffering from ailment, so they could not file this appeal within time.
So it's wait before the doctors to control the delay of
So now,
83 days. And
now you come to the array of the appellants. Who are the appellants? How many appellants are there? 6 appellants?
there are 6.
6 appellants. So the ladies, 2, respondent number 1 and respondent number 6, ill. Who are the others? 2, 3, 4 and 5?
Anupam Hasda, 3 Rajesh Hasda, 4 Ashutosh Hasda, on to by ourselves of date by March date, petitioner number, print number 1. Father of the sons of date by
2 to 5 are son of 1. So do you mean to say that this lady would have come to file this appeal leaving these sons who are aged about 45, 40, 27, 37 years? Is it believable, the statement which has been given in your petition in paragraph 4? So the old ladies would have come to the court to file this appeal, leaving out this 2, 3, 4 and 5. I'm just asking you, as a prudent person, would you believe this? आप विश्वास कर सकते हो स्टेटमेंट में कि जहां 45 साल का लड़का है, 40 साल का है, 27 साल का है, 30 साल का लड़का लोग है, उनको छोड़ के एक 65-70 साल का एजेड लेडी आ गई अभी फाइल करने? क्या आप रॉन्ग कह रहे हैं? डिले का हुआ है, इन दोनों ने देखा, इन दोनों को बीमार था। ऐसा नहीं लिखे कि दोनों बीमार था, बाकी लड़का लोग उसका देखभाल कर रहे थे बोल के आने नहीं सके। वो अपने आप लिख रहे दोनों बीमार था इसलिए अपील फाइल करने नहीं आए। As such, they have been able to file this present appeal within the stipulated time. आइए Mr. Tiwari.
Yes, sir.
You take your seat. Let him. He's a new junior.
Yes, sir.
Let him first be acquainted with the order sheets and all these things.
We are
He's
okay.
a 21 batch, COVID batch. He doesn't know even what is an order sheet. He cannot even identify the order sheet, physical order sheet of the court. बोलिए जो पैराग्राफ 4 में लिखे हैं, क्या लिखे हैं पैराग्राफ 4 में?
The appellant number 1 and appellant number 6 being senior citizen, senior lady citizens, age of 65 years and 66 years respectively, being suffering from many ailments. As such, they have
been able to file the present appeal within the stipulated period. Negative word to the studio. As such, they have been able to file this present appeal within the stipulated time. इसका मतलब क्या हो रहा है? They are able to file this within time. मतलब यही हो रहा है ना कि बीमार है, but they are able to file it within time. अब बताइए हम क्या करें इस पिटीशन? आप बताइए तिवारी जी कौन ड्राफ्ट किया है?
Your Lordship, whoever has drafted, but I will have to take it on my own shoulders. Whoever has drafted this, but I will have to take it on my shoulders as if it is my wrong.
And you think that this, even that negative word is not there, that because respondent number 1 and 6 are aged, this appeal couldn't be filed within time.
Yes, sir.
Appellant number 1 and 6 are aged person. The son of appellant number 1 are all aged 45, 40, 27 years. What prevented them? Is it a plausible explanation? Mr. Mahesh Tiwari seeks permission to withdraw IA number 3135 of 2000 and 31 कितना होता है? 7135 of 2019 with the liberty to file a fresh application.
Yes.
Yes, this case once the said application is filed.
Serial number 25 with 26, MA number 515 of 19, with MA number 362 of 19, Mr. Pratyush Kumar for appearing first case, Mr. Patumato for appearing second case, Mr. Alokal for responding in second case.
IA is for confirmation with IA number
National Insurance.
Yes, Your Lordship.
Who is appearing on the other side?
Yes, no,
On the other side?
I received the order from the college.
File, have you filed it?
Yes.
File करती है.
नहीं किया हमने, कर देंगे.
कीजिए, दीजिए.
Lordship, if the Lordship permits me, can I bring you the copy of the application?
Second case, first file the वकालतनामा.
सेकंड केस में जो हम अपील काट कर रहे हैं इसमें 34 के अंदर डिले है.
Where is the वकालतनामा in the first case? Ready है? Is it ready?
हम लोग रेडी कर देंगे.
कर देंगे तो दूसरा बात.
कर देंगे.
Yes, Lordship. One.
हैंड ओवर quickly ले लीजिएगा, endorse कर दीजिएगा. Mr. Sadhu Manu submits that he will be appealing on behalf of the claimant respondent in MA 515 of 2019. He has produced the wakalatnama, which is accepted. Copy of the memo of appeal is served upon Sadhu Manu. Limitation kind of limitation IAM is taken up on the consent of the parties. Both IAs have been taken on the consent of the parties. After hearing this also and after going through all of it, this IA is allowed to hear control. This case is under the heading for admission.
The Lordship for is grounded on the fact that there is a issue of notice.
Let it come under the heading for admission to see whether your case needs to be admitted or not. Then the question of notice.
It is the heading for admission, serial number 27 with serial number 28, MA number 145 of 50, with MA number 252 of 50, Mr. Arvind Kumar Lal for appealing first case, Mr. Alok Lal for appealing second case.
The first of all, he was apprehending his matter will not be taken up because of this first appeal. Pass over.
Then let it be after the days. After vacation.
After vacation, like this. Any chance of settlement? No chance of settlement.
Because I have filed for enlargement, the insurance company has filed for shifting the land.
The owner, you are the owner?
Yes.
Yeah.
There are two owners now. One has died, but they have not filed any substitution petition.
Information is
That is in the order sheet. I have informed a little bit.
Who is that?
Sir,
How many vehicles are involved in this case?
one
Two owners means?
joint owners.
So you face the liability. Joint owners.
They were party, both were party.
Any chance of settlement? Why, on what ground the liability is sought to be shifted? License was
License there.
then?
One of the point they are saying that this is the different vehicle which was insured, but that is incorrect. Actually, in the permit, the vehicle was subsequently changed, therefore number is different. Police has copied the
Wrong number.
Wrong number. One of wrong.
can NCR may kindly call for
Yes. Who is dead?
Malad,
Yeah, respondent number 2 has expired. Mr. Arvind Lal.
Who in first case and respondent number 8 in the second.
Mr. Arvind Lal does not एक ही order में Mr. Arvind Lal and Alok Lal submits that they will file an appropriate application in view of the fact that respondent number 2 is dead. The owner of the vehicle, one of the owner of the vehicle involved in the accident is dead. So this case is adjourned. In the meantime, follow the local records.
Serial number 29, MA number 457 of 50, Mr. Rahul Kumar for appellant, Mr. Ashutosh Anand, Mr. Abha Ahmad for respondent.
In this case, the appeal is against the order passed by the learned presiding officer of the lower court in the ESI case. What has happened in this case, the appeal has been dismissed.
In which case?
This
ESI.
Employees State Insurance Act.
Yes.
The appeal has been dismissed on the ground of being barred by limitation because the appeal has been preferred because the learned labor code has dismissed the appeal. This is the appeal because the appeal before the labor code because has been dismissed because on the ground of it being barred by the period of limitation of 3 years because. And my respectful submissions for my lord's kind consideration had been that because it is not barred by limitations because the determination under section 45 of the ESI Act has been because on 4/1/2011 minutes. And thereafter the appeal has been preferred on 6/6/2013, that is well within the period of 3 years because prescribed under 77 of the ESI Act. And that is the reason.
What was your challenge in the ESI case 3 of 13?
The challenge was to the order of the determination as well as
Which order was under challenge?
the order of determination is there not at page number annexure 6 page number 41.
No.
Plus. May I place the import order for it?
You challenged the assessment order dated 6/6/2013.
6/6/2013 is before this Milord's. 6/6/2013 Milord's, my appeal has been preferred as against the order dated 4/1/2011 Milord's and the demand notice.
Just read the order.
Months. That starts from page number 71. Step has been taken on behalf of both the sides through their counsel and the case is fixed for order after hearing of the petition of the applicant filed under section 5 of the Limitation Act and the rejoinder thereof filed by the opposite party ESI. While petition dated 6/6/2013 applicant has stated that applicant has challenged the assessment order and the warrant of arrest issued under the signature of Deputy Director and Recovery Officer ESIC directing the petitioner for payment of ₹1,80,000 plus interest on the contribution amount for the period of September 2007 to March 2008 and June 2008 to October 2009. Further, that against above assessment order, the applicant preferred a writ petition before the Honorable High Court being WPC number 2015 of so and so and for the relief. But on 7/5/2013, the above writ petition has been withdrawn by the applicant petitioner for filing case before the appropriate date. Hence, instant case is filed before this court. Further, that for the above circumstances, there has been delay for filing the appeal in the instant court, and the delay has been also been caused in obtaining the certified copy of the Honorable High Court order on 21/5/2013. And after taking legal advice from the counsel, the applicant has filed the instant case appeal. So, prayer has been made to condone the delay for filing the appeal under section the provisions of section 5 of the Limitation Act. Copy of the petition has been served to the contesting opposite party ESI, and rejoinder has been filed on behalf of the ESI opposing the petition on the ground that petition and the reply is not maintainable either in the eye of law or in the fact that the opposite party has filed show cause mentioning all grounds of rejection of this case and the same may be treated as part of the reply of the instant petition. Further, that the opposite party has rightly taken steps against the applicant under the ESI Act and rules and regulations for regularization of the contribution due and such order was passed by the competent authority after giving full opportunity to the applicant for complying with the demand made as per the opposite party, and thereafter necessary action has been taken as per the provision of law. Further, that there is no provision for condoning the delay under section 5 of the Limitation Act because the ESI Act has got the status of a special act and the prayer has been made to reject the petition and further petition has been filed in this regard with the prayer that limitation matter be decided as preliminary issue and on the basis of the preliminary issue and on the ground of limitation and maintainability case be disposed of. Learned counsel for the appellant has argued that the delay has been caused in filing the instant case due to preferring the matter before the Honorable High Court and there is no intentional delay or on behalf of the applicant. Further, that the applicant has not given any sufficient opportunity to put his case before the ESI authority and in the interest of justice condonation of the delay under section 5 of the Limitation Act is very much essential and further that delay can be condoned in view of the judgments of some of the high courts. In support of the above contention, learned counsel for the relied upon the decisions reported in 2002 LHJ so. On the other hand, the learned counsel for the opposite party has argued that petition of the applicant is not maintainable either in the eyes of law or facts. Further, that there is no provision to condone the delay the matter of the ESI Act under section 5 of the Limitation Act and petition of the applicant is without affidavit and verification. Therefore, such petition is liable to be rejected and further that since there is inherent defect in this case, because suit has been filed beyond the period of limitation. So cause of the applicant should also be dismissed as being time barred, and this is the legal issue which can be decided as a preliminary issue. Further, the ESI official, deputy director and recovery officer have rightly taken steps under the provisions of ESI Act after giving reasonable opportunity of applicant, and instead of paying the contribution amount for the required period, applicant has lingered the matter before the High Court and thereafter withdrew his case. And since case has been filed after passing of the limitation period, so the provision of Limitation Act is not applicable in such case and has prayed to dismiss the instant case of the applicant as being time barred. In support of his contention, he has relied upon the judgment so and so so and so. After hearing the arguments of both the sides and perusal of the case record, it transpires that applicant Vinod Kumar Thakur has filed the instant case under section 75(1)(g) and 75(2)(b) of the ESI Act against the opposite party for setting aside the demand contribution made by the recovery officer while his order dated 11/11/2009, this is very relevant, and 4/1/2011 for payment of the contribution of amount of rupees 1,80,000 and 1,80,180 for a period of September 2007 to March 2008 and June 2008 to October 2009, and also quashed the warrant of arrest issued against the applicant. After notices, opposite party has appeared and filed the show cause with the argument that opposite party has rightly paid the demand from the applicant because there were 21 employees working in the applicant's firm on 1/10/2007, and the opposite party has rightly requested the applicant for depositing the contribution in the ESI as per the provisions of ESI Act, and accordingly ESI has allotted code to the applicant, which is code number so and so with effect from 1/9/2007, and the establishment of the applicant was covered under the ESI Act. Further, that case of the applicant is barred by the law of limitation because case has been filed after passing of, this is very relevant, after passing of 3 years from the first date of cause of action. So, case is worthy for dismissal on this ground alone, and the opposite party has been given ample opportunity to the applicant for representation, but applicant did not avail the opportunity. Then order dated under section 45A of the ESI Act was passed, and if the petitioner was not satisfied with the aforesaid order, then he should have preferred an appeal under section 45AA of the ESI Act. But rather than preferring any appeal under the above provision, the petitioner has moved before the Honorable High Court, which was not proper forum, and accordingly prayer has been made to dismiss the case of the petitioner. Since applicant has filed petition under section 5 of the Limitation Act, and as per the provisions of section 77(1)(a) of the ESI Act, every such application shall be made within a period of 3 years from the date from which the cause of action arose. So certainly this is a legal issue, and a bar has been imposed for filing a suit within a specific period. So this case will be decided on the basis of preliminary issue as mentioned in order 14 rule 2 of the CPC, and the provision of order 14 rule 2 of the CPC runs as follows. Where the issues both of law and facts arise in the same suit, and the court is of the opinion that case of any part thereof may be disposed of on an issue of law, then it may try that issue first if that issue relates to jurisdiction of the court, a bar to the suit created by any law for the time being enforced. Further, on perusal of section 77 of the ESI Act, it is crystal clear that applicant has to present the application before the court within a period of 3 years from the date from which the cause of action arose. In the light of our provision, if the instant case of the applicant is analyzed, then it will be clear that the contributions amount has been demanded by the opposite party for the period from September 2007 to March 2008 and June 2008 to October 2009, showing first cause of action September 2007 and June 2008. Further, on perusal of the cited decision, I find that the Honorable Bombay High Court and the Honorable Karnataka High Court are of the view that in special cases and facts and circumstances, delay can be controlled by the court if the delay is genuine and bona fide. But at the same time, the Honorable Madras High Court, Honorable Orissa High Court, and in the subsequent judgment, Honorable Karnataka High Court has been pleased to lay down the principle that application under section 75(1)(g) of the ESI Act filed more than 3 years after the date of which the cause of action arose, then such application will be barred by limitation under section 77(1)(a) of the Act. Further, Honorable High Court has also laid down a principle in a case of reported in 2009 following LLJ that it is the duty of the court before entertaining the petition to see as to whether the application filed for the relief is within the time period of limitation, if any provided, and if any suit is instituted, appeal preferred, and applicant made after the prescribed period shall be dismissed even if limitation has not been set up as defense. Further, Honorable Orissa High Court has been further pleased to lay down the principle in a case reported in so-and-so that if any case has not been filed within 3 years from the date from which the cause of action arose, then the Employment Insurance Court has no power to condone the delay, and the Honorable Calcutta High Court has also been pleased to lay down the principle in the case of Kohinoor Trading Work and so and so reported in so and so, that the ESI Court, being creature of a statute, had no power to condone delay by invoking Section 5 of the Limitation Act. In this regard, the judgment of the Honorable Jharkhand High Court is also very much clear on this point, and the Honorable High Court in its latest judgment given in miscellaneous appeal number 137 of 2009, that is Sajjan Kumar, dated 31st of January 2015, that if the case has been filed by the appellant which is barred by the law of limitation, then the appellant is not entitled for any relief. Rather, the appellant is liable to pay the contribution amount since as claimed by the ESI Corporation. Since applicant has filed instant case after passing of more than 3 years from the date of first cause of action, so case of the applicant is clearly barred by Section 77 1A of the ESI Act. Thus, keeping in view the above provision of law as well as the decision of the
Where is your memo?
No, my memo is not there on record, but Milos will appreciate one thing, that the application has been filed on 6/6/2013. Only 2 dates are relevant, Milos. That is the first paragraph, opening paragraph.
Which application was filed on 6?
The 6/6/2013, Milos.
Before the?
Before the ESI Court, Milos. That is Annexure 16, page 59, Milos.
Annexure?
Annexure 16, page 15. Only 3 dates are there, Milos. I'll just place the lines upon that.
16 at page 29.
5/9 of my Milos, of the appeal.
Page 59.
59. Milos. Six 2013, this appeal was filed under Section 74.
Assessment dated 11/11/2009.
11/11/2009 is the demand notice which was under challenge. The determination order is 4/1/2011, and the 13/1/2011 is the warrant. Those 3 aspects were challenged. That is there in the input order itself.
Where is the final order?
The final order, Milos, 4/1/2013, Annexure 6, Milos, page 41. 4/1/2011.
Page 41.
41, Annexure 6. This is the order under Section 41A of the ESI Act. 4/1.
Can you challenge this order?
Milos, we have challenged this. Now, my
This is the final order.
This is the final order. This mentions of the demand also of 11/11/2009. Now let's
So this order is under challenge.
Yes.
4/1/2011. So is it beyond the period of limitation or within the limitation?
And for a moment, only two provisions I'll just indicate. Milos, may kindly have a glance to Milos, section 45A Milos. The order has been passed under 45A itself. And then I'll come to the
45AA.
45A. No, Milos, 45AA Milos, I can prefer an appeal before the appeal. This order is under section 45A Milos. On the top it has been mentioned.
You are not filing any appeal under 45A?
No, Milos, I have not preferred an appeal before the appellate authority.
Why?
Milos, there are two provisions available to me, Milos. One, I could have preferred an appeal before the appellate authority, Milos, by depositing 25% of the amount. Thereafter, Milos, within 3 years, Milos, my respectful submission, I by depositing 50% could challenge the same before the ASI court, Milos, under section 75, which I did, Milos.
Yes.
Milos, I'll just come to, Milos, may kindly have a glance to, Milos, I'll come to 45A.
45? Capital A.
Capital A. The order is also under 45A, Milos. 41 page पे ऊपर में लिखो.
45 capital A.
Milos. Milos, that speaks of the determination of contribution in certain cases. That determination has been done. And the second proviso, Milos, second clause 2 of this, Milos, section is very relevant. Milos got that. An order made by the corporation under subsection 1 shall be sufficient proof of the claim of the corporation under section 75 or for the recovery of amount determined by such order as an area of land revenue. So my submission would be that this is the claim of the corporation under section 75. And now, my lords, may kindly have a glance to section 75 and 77 for a moment. 75 provides for the appeal before the ASI court, and the 77. What is the cause of action, Milos? It would arise from the date this, Milos, has been decided. That is what is the intent of the legislation. 75 and 77.
There is an appeal.
Milos. 75 is the appeal before the insurance employees insurance court, Milos.
75.
Milos. And the condonation of delay, Milos, the provision, commencement of the provision is under 77. Milos.
What is the provision of appeal?
Milos, 75. 75G, Milos. And 2B, Milos, postulates that I have to deposit 50%. And Milos, the commencement of the proceeding has been taken.
Just a minute.
Milos.
Where is the limitation provided?
77 minutes.
77?
77 1A minutes. Every such application, let's got that. Every such application.
Which application?
Every such application.
Which application?
The proceeding, let's may kindly have a glance. The proceeding before an employee insurance court shall be commenced by application.
Yes.
And now every such application, I am reading 1A.
So which type of application this 77 is referring to?
It is referring to any dispute in between the employer and the corporation also, which is stipulated in 1G.
77 provides for a remedy in respect of 75.
Minutes.
What is 75?
75 says matters to be decided by the ESI court.
Yes.
Because I am referring to G part.
G part in that?
Any other matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, I am not following in this, or between a person and the corporation, or between an employee and a principal, or immediate employer in respect of any contribution or benefit or other dues payable to recoverable under. So my case would fall dispute between a principal employer and the corporation.
What is the difference between 75 and 45?
45 is below the determination. The determination way 45 is the determination of the Milord's liability contributions.
So in this case, the contribution has been determined.
Yes, 45A has been determined, Milords,
Yes.
and this is under challenge under 77.
Can that be challenged under 77?
75 and
Can
77,
that be challenged under 75?
Milords, that is under.
An order under section 45A can be challenged under 75, or it should go before 45A only?
So far that part is concerned, Milords will only appreciate one thing, Milords. Kindly have a glance to Milords 75 1A also, Milords.
Yes.
77, I'm sorry, Milords.
70?
Milords, I'm sorry, Milords. Section 2B of this, 75 2B.
75 to
2B.
B.
2.
Yes.
No matter which is in dispute between a principal employer and the corporation in respect of any contribution or any other dues shall be raised by the principal employer in ESIC code unless he has deposited with the code 50% of the amount due from him as claimed by the corporation. So there is a rider, Milords. Milords will appreciate that before the adjudicating authority under 45A, Milords, I had to deposit 25% of the amount.
See, there are two chapters,
Milords.
chapter 4 and chapter 6.
Milords.
Chapter 4 and chapter 6. So what is this difference between this 75 and 45?
45A, Milords, it postulates that I can prefer an appeal before the adjudicating.
45.
45.
What is the scope and ambit of this chapter 4
So far,
and section 45 capital?
45 capital A is in relation to the determination of the contribution. It says, Milords, is the adjudication.
45 ways gives power to determine
The pass an order with respect to the Milord's claim.
the
They determine,
contribution.
and naturally, Milords, the
The
contribution.
order determine the amount of contribution payable in respect to the employees of the factory.
And two
Provided that no such order shall be passed by the corporation unless the principal of the immediate employer
That is
be
not-
heard.
that is not-
Provided no such order shall be passed by the corporation in respect to the period of 5 years from the date on which the contribution were.
And now the clause 2, Milords, reads that an order, Milords, for that, an order made by the corporation under subsection 1 shall be sufficient proof of the claim of the corporation under section 75. Milords.
What do we by claim of?
Claim, Milords, the demand is finalized by way of the claim, Milords. That is the finalization of the demand.
So where are you saying that?
Because Milords will appreciate that notices
An order made by the corporation under subsection 1
One.
shall be
sufficient proof of the claim of the corporation under section 75.
for
For the recovery of the amount determined by such an order as an area of land revenue, because that is not related to this. Now, Milords, kindly have only one for a moment, Milords, 77 for a moment.
no, this let us say 75.
Milords,
Matters to
to
be
be
decided.
decided by the ESI code. G is there, Milords. If any question or dispute arises to, because the first is in relation to person of an employee within the meaning of that is not there, Milords. The second is the rate of wages and so and so, that is also not. The rate of contribution, Milords, that is also not there. The person who was a principal, that is also not, Milords. The right of any person or to have a benefit, that is also not there. Any direction passed by the current corporation, this is not 55. Any other matter, Milords, which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or
Any
between
other matter means?
Milords, any other matter means
You need to say any other matter which is also covered under 45.
that is the reason, Milords, the 45(2), Milords, categorically says 45(2), Milords, kindly have a glance, Milords, that categorically says, Milords, the claim of the corporation. That categorically says.
Prima facie I am not satisfied.
Milords, kindly have only one thing, Milords, only one part, Milords. Thereafter, Milords, for a moment, Milords, 77 will clarify to a considerable extent, Milords, what is subject to Milords. 77, commencement of the proceedings.
Commencement of the proceeding under section 75.
I'm just coming to the second 2B, Milords. 1A, Milords. Every such application
Yes.
shall be made within a period of 3 years from the date on which the cause of action.
What is the cause of action?
The cause of action, that is what I was submitting.
What is the cause of action?
The cause of action is the determination of the claim under section 45A. Plus, may kindly have a glance to 2B of that also. The explanation B to that. Explanation B to that. The cause of action in respect of a claim by the corporation for recovering contribution, including from the shall be deemed to have arisen.
Recovering contributions. So,
Shall be deemed.
Mr. Counsel, after this is quantified, there is a process for recovery.
Milords.
So, it is in respect of that.
The cause of action in respect of a claim by the corporation for recovering contribution.
For recovering the contribution. First, the contribution has to be determined.
Milords.
Then there is a proceeding.
That is.
So there is a proceeding for recovery. By this annexure 6, there is no proceeding for recovery, it is only quantification.
Milords.
So how will it come under this provision?
That's what I am respectfully submitting. Milords. First of all, there has to be an adjudication of the claim. The claim can be finalized only under section.
Claim of what?
The claim I mean to say, Milords, the contribution.
What do you mean by claim?
The contributions, the determination of the.
Where are you getting the word claim?
Milords, it is coming here only, Milords. 45A2.
Yes, read that.
An order made by the corporation under subsection 1 shall be sufficient proof of the claim of the corporation.
Yes. Sufficient proof of the claim of the corporation for what?
Under section 75.
75 means?
75 means the appeal before the.
No. 75 relates to 75 is appeal is not 75. Appeal is 75 is not an appellate power. It's the original jurisdiction of the ESI court.
That is there.
75 is the original jurisdiction of the ESI court.
Milords.
The matters they refer to there. Appellate power is 45A. So this, by challenging this, the court has to use the appellate jurisdiction, not the original jurisdiction.
That is what I am respectfully submitting for my.
Show me any
Because
decision.
that on that point, because I made a research, because thorough, because
Show me any decision.
that part I could not get a judgment to the extent, because the cause of action
There
is,
cannot be two appellate provisions in a law for challenging a similar order.
that I could not do. Milords' observation is Milords is
You have
That-
not challenged this order under 45. My question would be this appeal, whether without challenging this order under
45AA.
Pass under section 45, in terms of 45AA, can you invoke section 76?
Milords, for that purpose only I was relying upon the.
This is 75(2), what you are reading,
Milords.
is in respect of 75 only.
Milords, it is
This is the original jurisdiction.
Milords,
You over here, you are challenging you are trying to invoke the appellate jurisdiction.
that appellate jurisdiction, Milords,
It's 45AA.
45A.
So,
What I respectfully submit for my Lord's kind consideration, for 75 1G, Milords, it says that any other matter which is in dispute, and for that only reason.
this proceeding,
Milords.
any proceeding under 75 will start with an application. Just see a suit. A suit, there is a cause of action.
Milords,
You have to file a claim before the court. 75 also initiation will be by a plaint, not by an appeal. By challenging an order. In a suit, can you challenge an order
no,
of a court?
that cannot be. It has to be for a
It has
declaration.
to be a declaration.
Milords.
Initiate, it should be by a plaint. The 75 envisages somewhat that sort. But prime of it, I am saying, if you can satisfy me,
Because Milords will
if you
appreciate.
make research, if you can satisfy me, that's a different thing.
Let it then be posted after.
Because 75 says the matters to be decided by the employees. These are the matters.
These are
These are the issues which
issues
have to be decided.
which can be added.
But here there is an order. You are challenging the appellate order. Can this appellate order be a subject matter of a original jurisdiction in the suit? Can it be if the same parameters are used?
That is that.
Think on
I
this.
got query. I understood the query. Because
After vacation of the request of the council. Because two operates
but
are
may not still
absolutely
appreciate
different.
one thing on the point of limitation. Will not the learned.
No, then the question is limitation is not at all applicable if 77 is not. You have not filed
that
and
would-
that will become final. The 45A order is final. Because you have not challenged it in 45A. It says any order passed under 45 is to be challenged in
Appeal is under
45A.
45A.
That means that the only provision of appeal is 45A. There is no provision of appeal, and 75 is not an appellate provision. Answer this.
I'll answer. So I'll make a research on this.
Yes.
It's something new to me also. Not that easily.
Answer
Oblige.
this.
Serial number 30 with serial number 31, MA number 517 of 50, with MA number 518 of 50, Mr. Arvind Kumar Lal for appealing in first case, Mr. Manish Kumar for appealing in second case.
In my case, my lord, perhaps the order of the vehicle has not appeared in my case, but in second case, the insurance appeal they have appeared.
Who is the owner of the vehicle?
Comment number 2, madam. I am appearing for the respondent number 2 and 3, owner and driver.
You are
In 31,
in 30.
item 31.
What is the name of the owner and driver?
The same keep name of the Satinder Kumar Jaswal.
So you appear in this case. Are you appearing? Will you appear?
No, my lord, I have no from the Okalatnama, my lord.
Seek instruction.
I have informed my lord the concerning lawyer of the that place, my lord, but till now no Okalatnama was given by the owner.
They took after some of the cases, my lord, so that in the meantime they were
No, I think I had passed an order whether he will appear.
Yes,
Order has been passed, my lord.
earlier they can.
I have tried to for the Okalatnama, but till now, my lord, concerning lawyer of the that locality, my lord,
When was that order passed?
order was passed.
Order was passed or not?
Yes, order was passed. So may be notice, my lord.
No. It is not been passed.
Order has been passed, my lord.
Oh, sure.
These are the keys.
Yes, my lord.
These
Order has been
are
passed.
the keys.
देखिए तो Mr. Farooq Ansari, learned advocate, submits that he has till yet not received any instruction from his client whether to appear in his client as to whether he is authorized to appear in MA 517 of 2015 or not. He prays for last indulgence. Considering his submission in this case 2 weeks after the summer vacations, so it is made clear if no instruction is received by then, this court will direct Mr. Ansari to represent the owner of the vehicle
And driver.
and the driver of the vehicle in MA number 517 of 2015 also, as because the same owner and driver is being represented by him through Okalatnama in MA 518 of 2015.
50. Madam.
Serial number 32, MA number 460 of 60, Mr. Arvind Kumar Lal for appellant, Mr. Akid Ali, Mr. Alok Lal for respondent.
I think, my lord, that this case may be settled in this way.
हो सकता है पार्टीज कितना कुछ अमाउंट में डिस्प्यूट है
अभी
क्या?
अमाउंट में अभी कैलकुलेट नहीं किया है, लेकिन क्योंकि इसमें 2 डेट्स हुए थे, एक में लोन पूरा पेमेंट कर दिया, नो अपील, बट इन दिस पर्टिकुलर केस दे आर फाइल.
They are not paid.
The paid amount has been paid by the order of this one of the court, 9 lakhs rupees, something like that.
if the parties submit that the dispute can be resolved in the local Adalat. So considering the submission, let this matter be listed before the National Local Adalat to be held on 14th of May in the premises of the High Court of Jharkhand.
Both things.
Both. It's submitted by all the parties. It's referred to the local Adalat. Listed be referred to the local Adalat.
Serial number 34, MN number 245 of 17. Mr. Vijay Shankar Jha, Mr. Manish Kumar, for update, Mr. Gopal Vake, for responding.
But in this present case, I pray that let us take it up after rectification. The reason being is, my lords, that LCR is not with us and we have already given the requisition to the railways, procure the LCR and hand it over to us so that we can assist your lordship.
Claim was dismissed.
Well,
who will appear? You will appear.
I'll appear once.
Mr. Amit Sahai,
AC
AC to ASGI, submits that he will appear in this case, but the lower court records are not in his possession. He further submits that he has already sought for the lower court records from his client, which is expected to be handed over to him within a week or two. Considering submission, this case will be listed after some applications.
Serial number 35, MN number 417 of 70. Mr. Ranjit Mukherjee.
After I was praying for short fast over the complex.
Let us see what it is.
The probate matter, Your Lordship.
Probate granted or dismissed?
Rejected, Your Lordship.
On what ground?
Lordship, the only reason that they have taken is that the attesting witness at that one in his examination has stated that the contents of the will was read over to the testator and when the testator found it to be true, had put his sign. But in his cross at para A, he has said that the testator read the will and thereafter he has signed it.
That is the only ground.
Lordship, there are other points also, but this is the main thing that it has struck, Your Lordship. Further, Your Lordship, what is peculiar in this case is that there were 4 children of the testator, Your Lordship. 2 daughters and 2 sons. 2 sons and 1 daughter, Your Lordship, completely support the execution of will. The only objector objected to this point because according to her, she was not aware of the will, and according to her, the mother who predeceased the testator was also not aware of the will. And she stated that this has been done only to capture the share or her share in the property. The attesting witnesses have also disposed in my favor, Your Lordship. Of the 2 attesting witnesses, the first one has sworn on the affidavit that was filed for the application for the probate, and the second has came on record and attested in my favor. And the learned court has also taken the view that there was certificate to the effect that the will was read over and explained to the testator, but there is no certificate as to whether it was prepared on his instruction. That is
Suppose if there is no averment that it was read over and explained.
Lordship.
What will be the effect?
Lordship, there is no effect that is the testator.
Suppose if it is written in the will, nothing has been written that it was read over and explained. This part is not written.
Lordship.
And what will be the effect?
Lordship, that would not be.
Go and find out there is a judgment. Find out there is a judgment. What will be the effect if it is not written? So even if it is not written, in your will, it was written, something is written. Even if it is taken that it was not read in Manila, there is a judgment of Supreme Court.
Right.
Or must be Madras or something like this. Find it out. Call for the local records. Issue notice to the respondents, both ordinary and registered, both ordinary process. Requisites by 10th of June. Make them carry out the necessary corrections and ready. Carry out.
Serial number 36, MN number 555 of 70, Mr. Amresh Kumar for appellate, Mr. Kumar Nilesh for respondent.
My Lord, on instruction of Mr. Amresh Kumar, may I pray for not today as he was unwell.
You are the claimant. What is your ground? What is the ground for not paying the amount?
I am for drop on roads.
It's for the owner.
Yes.
What is the ground in the appeal?
They say that the certificate regarding the income, it is not a pay slip. This is the ground. It's B1.
That is the only ground.
That is the main thrust of the case.
How much? 8 lakhs. 8 lakhs. Where is Mr.
Amresh Kumar, you went to his home, my Lord. He was feeling unwell.
I am referring this matter to the local level.
I
Try to
will
resolve this.
I will.
Refer the matter to the local level. As there is a possibility of settlement of dispute. The Jalsa is directed to immediately contact the claimants.
Serial number 37, MN number 710 of 70.
A copy of this order be communicated to Jalsa so we can. Yes, next.
My Lord, this is an injury case, my Lord. The appellant was a daily hawker and he used to ferrying several.
Yes, Mr. Roy, any chance of settlement?
Inspection.
Injury case, any chance of settlement?
Yes.
It can be referred to the local level? Refer to the local level on the request of the parties. Call some of your officers so that the matter can be settled.
All right.
Serial number 38, MN number 760 of 70, Mr. Sachikant Thakur.
Supreme for password for the day.
Password for the day. Wait.
Council for the appellant matter, this is the election matter.
Yes?
Election matter.
Election में तो क्या करें?
Password.
Election में तो क्या? Election में
The application.
Where is the local record? place where the body was found?
The Jharkhand railway station.
Date of accident?
Date of accident by what states? P6/2016. P6/2016. 3rd of June 2016.
Date of accident 24/5.
But it's mentioned 3/6/2016. Date of journey is 24/5/2016.
From
Mumbai to Jharkhand. He was found in the Jharkhand railway station.
Ticket was from which place to which place?
Mumbai to Jharkhand.
General ticket.
General ticket. It is a case of breakup journey.
Huh?
It is a case of breakup journey.
Breakup journey.
Months.
Prayer has been made on behalf of the counsel for the appellate to adjourn this case after application. Full stop. The LCR is next one. Full stop. The LCR is already here, already on record. Since prayer has been made to adjourn this case without any alternative, this case is being adjourned. There being no other alternatives, this case is adjourned.
Serial number 39, MN number 112 of AD, Mr. Manish Kumar, for appellate, Mr. Seriously, for respondent.
Court number 10.
Serial number 40, MN number 117 of 80, Mr. Pratish Kumar for appellant.
My senior, Mr. Pratish Kumar, is on the left with the problem. Your option is, may I submit?
What is this matter?
There is a chance for settlement in the local.
It can be settled, Your Lordship.
Your insurance company can prefer an appeal only on the ground of quantum transfer. There is
But there is just like something. There is one appeal which we have filed based on behalf of the claimants.
For enhancement?
Yes.
Give me the case number.
That was dismissed for default, and we have filed a CMP to restore that.
What is the CMP number?
CMP number 291 of 2021.
291 of 2021 कल चढ़ाई है इसको this is not a tomorrow.
Serial number 41, MN number 130 of 80, Mr. Alok Lal for appellant.
not to the एक वायरस गलती से
रुक गया
वायरस गलती से आने का
Your counsel for the appellants prays for some time in this case. We are allowed in this case of some allocation.
Serial number 42 with serial number 43, MN number 24 of 21, with MN number 98 of 21, Mr. Amit Kumar Das for appellant in first case, Mr. Pankaj Kumar Chaudhary for appellant in second case.
Your case for enhancement?
Yes.
And you are appeal for? You is appeal for?
I am appearing for insurance company. Our instruction is that the matter has been settled between the parties.
Matter has been settled?
No. Matter has not been settled. They have deposited the awarded amount after filing this enhancement case. And enhancement
they have done
grounds.
So the matter can be referred to the local adalat.
They have withdrawn the execution case on the basis of the settlement, Your Lordship.
Then where is the settlement?
No settlement.
Bring all those documents.
Yes.
Parties of the matter. These two cases can be settled in the local adalat. Establish this case. Refer this matter to the local adalat on 14. You bring all those documents.
I have got, however, not the certified copy. Or
Yes, you have settled the dispute.
And subsequently, on the basis of the settlement, they have also withdrawn that.
You have settled the dispute.
That is order dated 10/12/2020.
That is lordship.
Yes, the parties were submitted, then both the parties have decided to compromise the case as per settlement between the parties. So once you compromise the case.
After filing this case.
So maybe after filing this case you have compromised the settlement. There is a settlement. Then who told you this enhancement is filed with?
They have also preferred an appeal, and we have.
Yes, they have preferred an appeal on 22/7/2021. Thereafter, you have after filing this is the order. Then
we had preferred appeal on 29th January.
No, they have preferred the appeal on 22/7/2021.
And they have
and thereafter this settlement. इसको लेते हैं ये उसने. Tell your client. Matter is settled already.
PL number 44, under the hearing under order 41 to the 11 of CBC. PL number 44, 21.
2-3 days time, Your Lordship, because I have called the client, Your Lordship. Just because even if he doesn't want to press this,
there is nothing.
Yes, Your Lordship, they're not meant. As such, it's nothing, Your Lordship. But there is no stay.
12. By way of last intelligence, the time prayer has been made to adjourn this case.
Yes.
Full stop. Execution case is proceeding.
Execution case is. It's proceeding and there is no stay in this.
By way of last intelligence,
there is no stay in this case.
This case on 12. It is made clear.
Or after the case, there is no stay in this case.
The counsel for the appellant prays for some time. She submits that there is no interim order operating in favor of the appellant. Full stop. Considering her submission, this case is adjourned to be listed after petition. It is made clear there is no interim order in this case. If any execution case is pending, the same is directed to be proceeded with as early as possible. Full stop. Let this order be communicated to the court concerned by fax.